Gentlemen, nice to have you with us. I want to start with you, James Paterson. And what is it that you feel that people should have the right to say that they can't say now?
Well, far be it for me to say what I want to say. I think we should know what Alex Wood, a student at the Queensland University of Technology, would like to say, and I asked him this very question at the Brisbane hearing of our inquiry. Alex said that he would like to say on Facebook that QUT is stopping segregation with segregation, and he'd like to be able to say that without being hauled through a 3.5-year torturous legal process, which has resulted in hundreds of thousands of dollars of legal bills on all sides, which has severely disrupted his career and his life, and which has resulted in severe impact to his reputation.
Senator McKim, is that just the sort of case, the Queensland University case, and I don't want to go into the ins and outs of it, but let's just say that that is a case that was widely seen as being one that should never have gone that far. Is that just the sort of case that does damage to the argument around keeping 18C?
Well, it does if you listen to the factually inaccurate comments that James Paterson just made. I mean, it wasn't a 3.5-year legal process at all, and James well knows that. The other point that the Human Rights Commission made is that their active engagement in that case was for about 4 months, which is very close in broad terms to the average length of time it takes the Commission to dispose of matters. But there's a broader issue here, and that's the right of Australians, and particularly multicultural Australians, to be free from racism. And I can't help, Stan, but chuckle at the irony of 3 privileged white guys sitting here debating with you with basically little or no lived experience of racism. But what we can do is actually listen to what we heard from the Jewish communities, the Muslim communities, Chinese, Greeks, Italians, Aboriginal and Torres Strait Islander people who told us about the horrendous lived experience of racism and begged us not to water down 18C.
And the report does talk about the need to be aware of the damage of racism and educating people around racism. But Graham Perrett, there also talks about what a reasonable Australian would expect. Ian Goodenough, the chair of the committee, has spoken of mainstream Australians. What's meant by that, and what would a reasonable or, quote, mainstream Australian expect?
Well, we can talk about what Ian Goodenough said outside of the report and what James Paterson said outside the report, but their names are on this report that clearly affirms the value of Section 18C and the great good it does in Australian society in combating racism. That's what they signed off on. They can have their private opinions, but there are 22 recommendations in here. None of them say change Section 2A of the Racial Discrimination Act.
It's not that clear though, is it, James Paterson? There are a whole range of different recommendations that are supported by one or more of the committee, and that's the point here. It really doesn't recommend anything.
Well, Stan, let's start where we all agree on a positive note, which is everyone agrees that the status quo as it is should not prevail, and at the very least we all agree that the human rights processes need to change to ensure that a case like QUT doesn't happen again. Now, my view, and that's reflected in the report recommendations, is that we also do need to go further than that. We need to change 18C itself, and I'd like to see some changes to 18D so that we strike a better balance between protecting free speech, but also making sure that the racism that no Australian wants to see remains unlawful, and there's still a path to address that. And I think a proposal which amends 18C will address both of those concerns.
So where does this go to from here, Nick McKim? We throw these phrases around Section 18C, Section 18D, but in the public's mind, this is a question of free speech versus racism, what is offensive, what is not offensive, and where the bar is set. So where does it go to from here?
Well, I think where it goes to from here, Stan, ultimately is a matter for the Parliament. But it is a bit of a test now for Malcolm Turnbull, because we know he's under pressure from James and his cohorts on the right of the Liberal Party. We know that Prime Minister Turnbull has made an art form out of appeasing James and his colleagues. So it really is now a test for the Prime Minister. But in the context of the broader points that James made, people do have a right to freedom of speech, of course, but it's not an unfettered right. It never has been and it never should be. And people have got a right to be free of racism. And we've heard of the impacts of racism on a range of multicultural Australia, the mental health impacts, the physical health impacts of racism. And they've been very clear with us to leave 18C alone.
But is there a difference here, Graham Perrett, between what is racist and what is harmful, and a process that can often be misused? And would you support tightening the processes here, the Human Rights Commission processes?
Well, that's what the Human Rights Commission has actually put forward to the committee, and the committee has signed off on that.
And would that,
James has signed off on that, Nick has signed off on that.
Would that be enough then to deal with the broader claims of freedom of speech or what is or isn't offensive?
Well, that's what the government majority committee has recommended. That's what this report in front of me, right here, right now, actually says this is what we should be doing. There's no suggestion of changing Section 18C. In fact, James has indicated that we should put more resources into the Human Rights Commission so that we can better educate people about the law and how it prevents people from making racist comments.
Every time you say there'll be no changes to 18C, I see James Paterson shaking his head. And the question for you, Senator, is what do you now expect from your leader? What do you expect from the Prime Minister?
Well, as Graham said, there was a range of views on the committee, and that's why we didn't come to any one conclusion about what should be done on 18C or 18D. What we've done is we've offered the government a range of options to choose from. So the government can now consider the merits of the case and take up an option. Now, my view is that it should proceed with both changes to the processes of the Human Rights Commission and changes to 18C and 18D, and I'm hopeful that they'll do that. The Prime Minister has himself said in the past that he thinks that offended insult should not be prohibited, that should not exist in the law, and he'd be comfortable with the reform which removed offended insult. Now, I've gone one step further in this report and also said we should take out humiliate but replace it with harass. I think that better targets racism and allows more free speech.
So you're expecting the Prime Minister to act on this? You're expecting to take a tougher line on 18C and bring about the reforms that you particularly want to see?
Well, I'm hopeful that he will, and I know a lot of my colleagues in the Liberal Party room feel the same way, but ultimately it's a decision for the government where to go here. We've offered them a roadmap. It's up to them to choose exactly where they go.
Graham Perrett, it really does seem to hover around this question of who is offended and who gets to decide what is or is not offensive in this mainstream Australian view, this reasonable Australian view. How do we decide that?
Well, look, there's someone called Kiefel, I think her name is, now the Chief Justice of the High Court, has actually looked at this in terms of case law and clearly said that it must be more than a mere slight. So the judicial consideration of the laws, the words of the Parliament, means that the bar is actually quite high, Stan. There is no way that people can run off and do frivolous things. We've seen that from testimony after testimony, from the nearly 1,400 submissions that we had, that there is a fair process in that we actually need to educate people more. That's one of the first recommendations of this report, is to educate Australia about their rights to freedom of speech, but also that balancing in terms of freedom from discrimination.
Senator McKim, there have been many cases that have been mentioned, of course, around this, and the most recent, I suppose, would have been the Bill Leak cartoon. Was that also another example of where something that was part of the public debate, that someone was accused of being racist and that ultimately did not even proceed? Was that another case of where something can go much further than it should?
Well, the Bill Leak case was settled very rapidly, and look, my view for what it's worth is that Mr Leak had a very strong defence under 18D for legitimate and reasonable political communication, so I actually don't think he would have been found guilty of breaching the Racial Discrimination Act, even if that matter had gone to the court. But the choice before the government, the choice before all members of Parliament now, is are we going to listen to what we heard during this committee process and stand with Multicultural Australia, or are we going to turn our back on them and ignore them? And the Greens will be standing with them.
Senator Paterson, a final question to you, and that is, how much of this really does resonate with the public? Is this really a first-order issue? We know that Barnaby Joyce, the Nationals leader, has said that no, it's not. When he goes out and speaks to people, they are not talking about this.
I think a lot of Australians are concerned and should be concerned that, as we've seen in the QUT case, anyone just expressing an opinion on Facebook could be hauled before the Human Rights Commission, could be forced into conciliation and could end up in court, and it could take 3.5 years to resolve. We learnt today that there are 71 complaints before the Human Rights Commission on 18C. Now, among those 71 could be the next QUT or the next Bill Leak or the next Ashfield Uniting Church, where the Korean community is responding to a complaint by the Japanese community because they erected a statue to comfort women in World War II. If we don't act, there will be more cases like this. That's the certainty. And I think we should act to make sure that free speech is protected as it should be.
Well, you've all signed the report, but by the reactions today and the shaking of the heads, clearly you don't all agree. But thank you, gentlemen, for joining us again.
Cheers, Stan.
Thanks, Stan.